be recording, and we are currently. So going through our housekeeping slides, if you do wish to receive a CME or CEU or attendance certificate, you do need to announce your name either verbally here in just a moment when we have roll call, or you can use the chat box through Zoom. So if you do want that certificate, you need to let us know that you're there. A computer video and audio, you have the power to turn that on and off. So take advantage of that. We would love to see you on camera as well, so it's not just us up there. So you can stop and start your video and mute your computer audio and then mute it there. If you're having trouble with that and need to get through your phone or have audio going through your phone, click stop video and start video with your telephone, and it'll give you instructions for that. Our disclosure and accreditation statements are on screen. And Molina Healthcare and Blue Cross Blue Shield New Mexico has partnered with us to reimburse you for bringing your case consultations to us. That is a part of AHI New Mexico, so get in touch with me about that. Some of the codes have changed, and we're trying to get those tracked down for you from Molina and Blue Cross. And at this point, we'll go ahead and take roll. And why don't we go ahead and go around the room and everyone announce who they are. And this is Kevin Whirling, Systems Analyst here at Envision New Mexico.
I'm Ricky Diamond.
I'm Kelly Boone, one of the pediatric residents at UNM.
I'm Jennifer Romero, Staff Attorney at Pegasus Legal Services for Children.
Hi everyone, I'm Emma. I'm an MSW intern here at Envision.
Hello, Carol Conley, social worker and education and outreach manager at Envision New Mexico.
Thank you all around the room, and anybody out there who is on audio who'd like to announce themselves. We do have a few people who have chatted in.
Could I personally, I'd like to welcome Christopher Cox. I see that you're on, Christopher, and I remember speaking to you last week, and thank you for joining our Adolescent Health Initiative, and I hope it's helpful for you as you plan a similar initiative in your state.
Thank you so much. It's great to be here.
Okay, I'm showing Lisa Armijo and Michelle Laporte.
Welcome.
And there are several others, and we do want to get started, so go ahead and use that chat feature to announce yourself, and we'll have another opportunity at the end, and we'll go ahead and turn it over to Carol.
Well, good morning, everybody. Welcome to Studio Envision. This is our third session in our Adolescent Health Initiative, New Mexico. It is our continuing goal to bring you up-to-date information and resources related to the care of teenagers. This is a certificate program, and in order to receive a certificate, you must attend 10 of the weekly sessions, 6 of them live. The rest you can view through our Moodle platform. Let's see, I lost my space. Complete pre and post participation surveys, present 1 adolescent patient case for consultation, and let us know if you're interested in the certificate. We would be so glad to help you sort through. I know a lot of you don't practice directly with adolescents anymore, but if there's any way we could help you design a case for presentation, we really encourage you to get the certificate and all the free CMEs and CEUs that come with it. Okay, so I would like to introduce Jennifer Romero. She is the staff attorney.
Charles and Zuni. I'm trying to send in by chat, but this is just my roll call. EJ, Charles, school nurse, and Zuni.
Well, welcome. Thank you. Okay, back to introductions. Jennifer Romero is the staff attorney in the youth law program at Pegasus Legal Services for Children. She advocates for children in and out of court throughout the state. Jennifer grew up in New Mexico and in 2002 received her Juris Doctorate from the University of New Mexico School of Law. She has been fighting for the rights of vulnerable populations ever since. Jennifer has also worked as a public defender and has served on the Public Defender Commission since 2016. She has been a prosecutor and a court staff attorney. We are so happy to have you here today to talk to us about consent and confidentiality with minors. So thank you, Jennifer.
Thank you. So At Pegasus, one of the things that we do, when I say in my biography, we help kids in and out of court, a lot of the work that I do is actually out of court. And a lot of it is young people calling in because they're having difficulty accessing healthcare. And so if you're a young person listening, that is something you can call Pegasus for. We also do a lot of trainings for healthcare providers throughout the state, and we also get a fair number of questions from them. So our training sort of evolves around what kind of questions we see a lot. You'll see that this training covers when youth can consent to healthcare, what is confidential when a youth is consenting to healthcare or receiving any healthcare. And we also touch on the issue of sexual consent because we get that question a lot, and mandatory reporting, especially from healthcare providers who say, you know, we had somebody come in, she's 15, she's pregnant, do I have to report this? So that's why that's part of this training, but hopefully what you'll walk away from here is just a general overview of when can minors consent to their own health care, what is confidential when a minor is receiving health care, and we'll touch on general health care and also mental health care. And let's see, make sure I'm pointing this the right direction. So again, just the overview of what we're going to cover today. And just briefly, you know, when we talk about consent, we're talking about the right to be able to make decisions, that the youth can decide to receive treatment, care, or medications, but it also means that they can refuse treatment, care, or medications. Now, as a general rule, parents and guardians consent to all care on behalf of their children. The exception is if you have a youth who is 14 or older, who is living apart from their parents, or who have a child themselves. So they're a parent, they get to consent to their own health care. They also get to consent to the health care for their own child. And so a 14-year-old living apart from their parents it doesn't really specify what length of time. So if you have a 14-year-old who's out of their parents' home for a week, staying in a shelter or staying with a friend and needs to consent to medically necessary care, they can do that. An exception to that is when there's an emergency and there's a minor in need of care and parents cannot be located. Let's say a minor is involved in an accident, or a paramedic finds a minor on the street in need of medical attention, then consent for emergency attention may be given by any person standing in loco parentis to the minor. So really, I think that can be interpreted as any adult can decide this person needs care. And we've done some outreach to some of the paramedic companies, the ambulance companies, and we're trying to find out how they interpret this and what they do when they come across a young person who's in need of care. Can they, as the adult, make that decision? Do they have to find somebody? And let's see, then we have reproductive health care, which includes treatment and testing for sexually transmitted infections, pregnancy-related services, and contraception. And we're going to specifically cover consent with regard to reproductive health care, because this is one where young people of any age can consent to reproductive health care. So a young person of any age can come in and get, for instance, a pregnancy test, or if they're having some problem with the reproductive systems, can get that medical care. There's no age requirement. Okay, so quick quiz here, just over the brief things that we've covered. Which of these people can consent to healthcare, as described in these questions, without parental permission? What about, you've got a 13-year-old youth who's living in a shelter and needs an x-ray. Can that person consent to health care? No.
No.
Right?
Could be the local. Okay.
But can the 13-year-old consent? No, but you're right. If the x-ray is because it's an emergency and there's somebody there at the shelter who's standing in loco parentis, yeah, they could consent. But the 13-year-old themselves saying, oh, something feels a little weird, I feel like I need an x-ray, not going to be able to consent. How about a 14-year-old youth who's living with her parents, has a 6-month-old son, and she wants a flu shot? Can she consent on her own?
Yeah.
Yes. And why is that?
Well, she's 14 and she has a child.
Right. She has a
She's
child.
A parent.
Right. And I heard the word emancipated, so I just want to say parents, young parents are not emancipated for all purposes. Just the healthcare. If they want to be emancipated, that's also something Pegasus does. But they would have to go through and file the petition and still have to be 16, as the emancipation statute requires. So how about a 13-year-old who's living with her parents who wants birth control, and her parents object to that? They don't want her to be sexually active. They don't want her to receive it. Can she get that? Yes. How about a 17-year-old who's on her parents' insurance? Let's assume she's living with her parents. That question wasn't really clear. She has a UTI and wants to be seen for care. Can she do that? This one's kind of a trick question, because the answer is maybe. She might be able to. If it's related to a reproductive issue, then she could consent. If not, then no. And a lot of this, if you're a provider who's listening, a lot of this requires you to really think about this. It's not simple. It's not really clear cut. But the important thing is to be honest and let kids know, hey, here's what you can expect. You can expect this to be confidential, or this is not confidential. I mean, I know everybody gets sort of a HIPAA, whatever it is, you sign that HIPAA disclosure, but that doesn't really explain the nuances here when you're dealing with young people, because sometimes it is confidential, sometimes it's not. And you'll see that consent and confidentiality are tied, because the exception that we talked about that talks about kids being able to receive health care, when you look at federal law, it says if the person can consent, then it's confidential. So if they're able to consent, it's confidential unless the law says otherwise, and we'll point out some places where the law does say otherwise. But if they're able to consent, then that should be kept confidential unless there's some exception. This is an area of law, like all areas of the law, where there's exceptions and there's exceptions to the exceptions. So again, it's not simple, but this is an overview. And the important thing is, if you're a healthcare provider, know your policies. You know, when are you going to, on the places where it's discretionary, do you have a policy on that so that you can explain to young people, under these circumstances, we're going to disclose this, or we're not going to disclose this unless these circumstances. Mental health services. And this is an area where New Mexico, I think, is pretty unique on this. Parents can consent to treatment on behalf of children, except a child under 14 years of age may consent to an initial assessment for early intervention services for verbal therapy. So talk therapy, if a child under 14 is seeking that, goes to their school counselor, for instance, seeking that talk therapy, they can consent to that on their own, to any counselor. Something to be aware of here is the difference between HIPAA and FERPA, and that's why before we started, I asked, are there school-based healthcare centers here? Because if it's a school-based healthcare center, and that means that it's not just in the school, because that doesn't determine what law applies. That means the funding comes from the school. So if it's that type of school-based healthcare center where the funding is coming from the school, then FERPA applies. That's the law on education, which we'll cover. I always forget what FERPA stands for. It's in this PowerPoint later, though. But FERPA is basically everything can be disclosed. Anything can be disclosed to parents. Once it's part of the school record, it's all disclosable. So again, the importance is tell the child when they come to you, you know, this is school-based healthcare, FYI, I have to just, anything that I put in my notes is disclosable to your parents.
Yes.
Because at least then they can make that choice, okay, I don't want to talk to you now,
Right.
you know, which is much better than having that information get disclosed without them being aware that it could be, and then trust is broken. Anyone who's worked with kids knows that's really important, because then they may not go back to you, they may not go back to anybody. Yes.
I just want to chime in a little bit. Because of that, for a while, the FERPA and HIPAA were bumping up against each other in Mexico really badly
Yes.
through school-based health centers.
Yes.
And there was a push to have school-based health centers taken over by FQHCs, so that then what was happening in the school-based health center could be protected under HIPAA. So I think that right now we have about 9 school-based health centers still flying out in that HIPAA, FERPA, as we refer to, FERPES. Yes.
Yeah. So, well, and then, but you also get into like school counselors who a student might come to
Right.
with some of these, you know, sort of emotional issues in need of sort of talk therapy, and just use caution there, because most school counselors are part of the school.
Yes.
And so that's covered by FERPA. But yes, I agree. I've seen a huge change, even just in the 2 years that I've been at Pegasus. There's been a big shift to where it's mostly not school funding
Right,
so that it is
right.
HIPAA, and that's important.
Protective. I think
Yeah.
so too. It's protective to the kids, and they need that space.
Right. Yes. Excuse me. This is where I think New Mexico is pretty unique. Children over 14 and older have the right to consent to their mental health treatment, including for substance use disorders. They can consent to psychotropic medications, but the parent must receive notice, and that's a must. Okay, so this is one of those that it's not discretionary. The parent has to get that notice, and so that's something that's important to tell the patient, to tell the child that, okay, yes, I can prescribe you X, Y, and Z, or Z, but your parents have to get notice of that, because again, then they can make the choice to do something else, or maybe have another adult help them tell their parent with them, but they have to get the notice. If a child 14 or over lacks capacity, there's a process for a parent to act as a surrogate without a court order. So the parent is still the parent. If I think that this statute requires at least 2 healthcare providers to have the opinion that the child lacks capacity, so there's still some protection for the child, but it doesn't require a parent to then go to court and say, my child's at least 14, but I think that they need to be on this medication or they need this treatment. There's a way to do it without going through all of that. So that's also, note that it's including for substance use disorders. And so this is where, if a parent thinks their child needs to get checked in somewhere for substance use, they can't do it without the child's consent if the child is 14 or older. And this also means a parent can't put the child on medication without their consent. So a parent can't go and even get a prescription for the child. I don't know, did anyone see the movie that came out recently, 13 Reasons Why? It was like a big thing with teenagers, but there's a portion where the mom is sort of she goes and gets this medication. I don't remember what it was, some sort of antidepressant, and presents it to her son. You really shouldn't be able to do that here, because the parent can't just say, here, take this. And I think, again, check your policies, but whose responsibility is it to tell the child that they have the right to consent, they have the right to refuse? I think that should mean that the parent can't just go get it and then present it to the child as you have to take this. Okay, so here's another little quiz. Who can consent to the following health care? A 13-year-old boy is feeling sad and wants to talk to a counselor about setting up a regular appointment. Can he consent to that? Yes. How about a 16-year-old girl is hearing voices and her sister convinces her to talk to her doctor?
Yes.
Yes. A 17-year-old wants to talk in private with his psychiatrist. Can he do that?
Yes.
Yes. A 13-year-old wants care for what she thinks is a sexually transmitted infection. Can she do that?
Yeah.
Yes. So all of these are yes, but we'll see in our section on confidentiality, the confidentiality that applies to each of these might be different. So confidentiality is just the right to control the access to information, and it requires healthcare providers not to release information about the patient except as allowed by law. Again, I'll go back to some of this is mandatory, like the parents must receive notice of the psychotropic medications, but some is discretionary, so know what your policies are and clearly explain that. The laws affecting minors' rights to confidentiality. HIPAA is in healthcare settings and FERPA is in educational settings. And then state law also affects HIPAA because HIPAA basically says if the state law allows consent, Health Insurance Portability and Accountability Act says generally parents do have access to their child's medical records. The exceptions are, and this is, the minor consents to care and consent of parent not required under state law. That's where I was saying if it's simply in state law, a minor can consent and the consent of parent is not required, what happens there. or the parent agrees to the confidential relationship. So the parent could agree and say, okay, my 13-year-old wants to talk to a therapist, wants me to not know anything, and so I'm going to agree to that. I mean, you do have parents who might make that agreement with the healthcare provider. FERPA, Family Educational Rights and Privacy Act, gives parents the right to access all their students' records. There is no state law exception. And you know, the spirit behind this law was good. It was because parents weren't able to find out why their children were being disciplined. They weren't able to correct their child's records. And so this law was put into place to give parents that access. But then when you get healthcare involved, that then falls under FERPA, and that means full access. Once it's made into a record, the parent has the right to access. And so you have to determine, are you working in a school-based healthcare center, or is it separate from the school? Again, that's tied to funding, not the site of the service. And FERPA also has this exception that is a required reporting that is not in HIPAA, that a school employee who knows or in good faith suspects that any student is using or abusing alcohol or drugs shall report such use or abuse pursuant to the procedures established by the local school board. So if you're working for a school and in any capacity, you should know what those procedures are. And that, again, that's especially important if someone's coming to you to confide something, to be able to say, hold on a second, I got to tell you, this is not going to be confidential. If you tell me this, I'm going to have to report it, and then maybe have a place to send them where they can send it to be confidential. That's why I think it's great that there's so many healthcare centers that are on site of schools, but not funded by the school. That way they have that access. They don't have to go somewhere else, try to drive somewhere else and get themselves there, but they can go there and seek what they need and still have that HIPAA protected confidentiality. So under confidentiality in New Mexico law, if a child is under 14, the child's legal custodian is authorized to control disclosure on behalf of the child. So the legal custodian can sign over, those disclosures so that somebody else can look at the medical records. The parent or legal custodian has the right to do that on behalf of their child. The child 14 or older has the right to control the disclosure of mental health records, except that the parents must get notice of psychotropic medications. And so this one can get tricky, because I can imagine that a parent might come in and say, well, why is my daughter on Prozac? And there you are with what, you've got now something that you can disclose, something that you can't disclose, or rather something that you must disclose and something that you can't disclose. Sometimes these compromises in the law, I think, make things really difficult for kids, because then that child goes home with parents, and I'm almost certain any parent is going to say, but why? What's going on? And so it opens some discussions, and I think it's just important that kids have to know that they should expect that they should expect that parents are going to get this notice, because it affects them. Confidentiality in reproductive health care is another area where I think, we made some compromises that affect, whether a child's actually going to seek this treatment. We wanted to have it available. The sort of policy in New Mexico was, we want everybody to get tested and not be afraid if they think they have a sexually transmitted disease. We recognize that people are sexually active way before the age of 18 sometimes. And so we wanted to make that accessible. But then you have this, portion who, this idea that, yeah, but can we really keep that from the parents? And so again, when laws come into place, there's often compromise, and that's where you get that minors can consent to testing for sexually transmitted disease or treatment. And those test results may legally be released to both the subject of the test or the subject's legally authorized representative guardian or legal custodian. So this is one of those areas where it's discretionary. And I think it's really important to let someone know ahead of time, when they're about to get this service, under what circumstances is that going to be released? What's the policy? If it's not an internal policy, do you have an individual policy that you need to disclose? That, if you, for instance, it may be that if you suspect that this was non-consensual, then, your then you're going to release it. That's just something that it's discretionary, so you have to know the policy or come up with the policy, but most importantly, communicate that so that the patient knows what to expect. Confidentiality is easily broken, and this is something that I think Medicaid is fixing now, or at least New Mexico's Medicaid provider. When parents or when the person who holds the insurance gets the bill or the what is that thing called?
EOB,
Yes,
explanation of benefits.
Sometimes it has on there what it was. Pregnancy test. Oh, well, that should have been confidential. It's not the healthcare provider that's releasing it to the parent, but it's this insurance, sort of bureaucratic thing with the insurance that sometimes it gets out there. Or even just the idea, just notifying the parent that the child went to the doctor is sometimes enough to prompt questions. And this is not something that kids think about. I always use the example of my own daughter. When she turned 18 a couple of years ago, she went to the doctor and they sent the explanation of benefits to her. And she got it and she said, "What is this? Why are they sending me this? Is this a new thing?" And I said, "No, that always just came to me." And she had no idea that these things were coming to me about her. As it happens, I generally knew when she went to the doctor, but it wasn't something that she ever thought about until after she was 18 and got one herself and realized, oh, all this time, you've been getting one of these every time I go to the doctor. And then, of course, the school healthcare providers. They may make notes which parents can access under FERPA. So again, we go back to like school counselor, a teacher, school social worker, or a school-based healthcare center that is receiving money from the school and is controlled by FERPA. So again, just letting people know this is what to expect. And it's not something that people know well, including lawyers and doctors, because we get calls all the time about this. Sometimes it's from the lawyers for healthcare providers who are saying, is that really true? What's the statute number? It's not something that people give a lot of thought to. Fortunately, most parents are responsible and their kids trust them, and it works that the parent gets healthcare for the child. But more and more, when we see children who are living apart from their parents, it's really important for everyone to know when a child can consent to healthcare. Sometimes lawyers and doctors make it way more complicated. Last summer, we had a situation where a child needed to go to the emergency room. He was staying in a shelter. Went to the emergency room and they treated him, and then they wouldn't discharge him because they said, well, the law says that we can treat him, but now what do we do that we need to discharge him? We don't think we can discharge him. And so, because they were trying to be cautious and not discharge a child who then had no place else to go. He was going back to the shelter, but it can get confusing sometimes, even for lawyers and doctors who deal with this stuff every day. And children are traditionally disenfranchised and don't know their rights. Part of that is sometimes children are more protected, like my daughter, who never had to worry about me getting an explanation of benefits. But sometimes they are, don't know their rights and are in a situation where they really need to know their rights. And oftentimes we as adults treat children like, well, you don't really need to know all of this. You're just a kid. But these are things that they need to know if they're coming to you seeking care, and especially if they're asking for confidentiality or talking about sensitive subjects. It's really important to explain the rights that apply specifically to them. Okay, here's another quiz. Which of the following situations will remain confidential? A 13-year-old boy is feeling sad and wants to talk to a counselor about setting up a regular appointment.
Mm-hmm.
Yes. Do you want to say why? Because he can consent to it, right? So if he can consent, then it's confidential. And the law doesn't say anything about it. The law doesn't say, but you got to tell his parents. How about a 16-year-old girl who's hearing voices? Her sister convinces her to talk to her doctor. Neither wants their parents to know about the appointment.
Maybe or no.
Well, first of all, can she consent to go talk to a doctor? This is a mental health issue, right?
Yeah.
So she can consent. There's nothing said about giving medication. So is it confidential?
Yes.
Depending on explanation of benefits, though.
Right. See, that's where it gets you. So between
Right.
provider and patient, yes,
Yeah.
but what is that explanation of benefits going to say? A 17-year-old talks in private with his psychiatrist who prescribes him Zoloft. He doesn't want his parents to know he is taking medication because they prefer a natural approach.
No, that won't.
No. So again, this is something for youth, know to ask these questions, like, are you going to tell my parents this? Do you have to tell my parents this? However you want to ask it. And for providers, make sure and let them know, because a kid isn't always going to say, are you going to tell my parents? And especially when it's something that's required. It's really important that they know that. And then we go back to, I think we already had this one with the 13-year-old. The 13-year-old wants care for what she thinks is a sexually transmitted infection. Is this confidential?
If it's not school-based.
If it's not school-based.
Funding. If it's not FERPA.
Right. How about if let's say that it's HIPAA and she goes in and she gets treatment or she gets tested. Is that confidential?
Under what?
HIPAA. Well, remember it says that it may be disclosed.
Yes.
So you have to know for your provider, is that something do you have a policy around that? Like, under what circumstances do you disclose it? Do you always disclose it? It says you may, but the important thing is just telling the child, hey, we can test for this, but we're going to disclose if your parents, and are you going to just send it to them, or are you only going to disclose it if the parents ask? What are the parameters here in making sure that the patient understands? Now, this is something that, again, it doesn't exactly relate to healthcare, but because there's such an overlap and the law is very different in every state, I think the state law that we hear the most about is California, which is the really strict law that somebody 18 or over cannot have sex with somebody younger than 18. I mean, it's pretty just bright line, minors and not minors, and if you're 19 and your girlfriend is 17, no, that's statutory rape. Right, don't have sex. So it gets confusing in New Mexico because the law here is not at all that clear. And then it's also, we have this mandatory reporting statute, and we'll talk about that and what that means, what has to be reported. But oftentimes, I did a presentation like this last year in Santa Fe, and one of the healthcare providers reported that one of her patients had reported being raped by a fellow student, but she didn't want to report it. She wanted it to remain confidential. The provider kept it confidential. Sometime later, another student had a similar incident, reported it, told the police, and it happened to that person too, the patient from the first patient I talked about. Police went to that healthcare provider and told her she had violated the mandatory reporting statute. She didn't report. Well, actually, she hadn't, but it gets confusing in that way because you're supposed to report abuse, but by who? Does that matter? And what's abuse? So we're going to get into a little bit of that and talk about the age of consent, just because I think this can make things really complicated and make healthcare providers feel really uneasy when you're dealing with someone who's very young, who's sexually active, especially when there's a suspicion that maybe it's not entirely consensual. So in New Mexico, the age of consent is that a child under age 13 cannot legally consent to sex. So any sexual contact of a child under 13 is not consensual. They simply don't have the capacity to consent. And the other party may be prosecuted regardless of age. I mean, technically, this means that two 12-year-olds having sex could both be prosecuted. That really doesn't happen. But, if you're under 13, you don't have the capacity to consent, and that's the only bright line that we have, I think. Then you get into what we sometimes call statutory rape, which means it wasn't forced, but did this child have the capacity to consent? And this statute deals more with power imbalances. So if you have a child who's 13 to 16 and the person they're having sex with is at least 18 years and is at least 4 years older than the child and is not the child's spouse, because in New Mexico you can get married as young as 14, I believe. 14 to 16 with a court order, and 16 and older with parental consent, I believe, is our current law. So you can have a spouse at under 18, and if your spouse is 4 years older than you, they're not going to be convicted under this statute. But if they are at least 4 years older and at least 18 years old, then technically that's what we call statutory rape, because it's not like somebody is reporting this was forced, but they don't have the capacity to consent because of that power imbalance. Also part of the statute is if the child is 13 to 18 and the person is a school worker, is at least 18 years old and at least 4 years older, and again, not the spouse of the child. So really the only difference here is that it goes all the way up to age 18. So here's a scenario. Christy goes to the school counselor for advice. She's 15, she's 4 months pregnant, and she's having abdominal pain. First of all, can she consent?
Yes.
Yes. And will the pregnancy remain confidential? Not forever, but obviously. But will it remain confidential?
For now.
As far as the healthcare provider goes, yes. Christy tells the counselor that her 19-year-old boyfriend is the father. Is it statutory rape if she's 15? Maybe, right? Depending on birthdays, maybe. What if she's 13 and her boyfriend is 17?
Then no go, because you at 13, right?
It's a child under 13. So at 13,
So I think it depends on birthdays again.
yeah.
It's 4 years.
Yeah. What if she is 16 and her boyfriend is 20?
That's okay.
Yeah, because it was 216, right? So even if she's 16 and her boyfriend's 21, that's okay. What if she's 15, her boyfriend's 25, and he is the school employee?
No.
No. If Christy comes in and she's 12 and she's pregnant, would the counselor have a duty to report to CYFD? Now remember, at 12, she does not have the capacity to consent.
Right.
Yes. Yes, you'd have to investigate it.
But then she's going to be a parent. So does that protection, like, she's a pregnant or parenting teen, give her some?
She's not a parent yet.
Right.
She can get, she can
'Cause it's
consent to the
reproductive
treatment,
health.
right?
Okay.
And so the answer is really, again, this is kind of a trick question, because the answer is maybe. You got to get more information, because reporting to CYFD and mandatory reporting, which this is the statute, every person, and even though they've laid out some people here, the Supreme Court in a case recently said, no, we mean every person. So I don't know why they had to list certain people, but I think they're trying to list people who might otherwise think that that it's confidential, like a member of the clergy. Even lawyers have to report under some circumstances. And what do you have to report? If you know or have a reasonable suspicion that a child is an abused or neglected child, it shall be reported immediately. Failure to do so is a misdemeanor, and I have seen some prosecutions under this. But what's the definition of an abused or neglected child? It's a child who has been abused or neglected by a parent, guardian, or custodian. And duty to report, if your duty is to report that you suspect a child is an abused and neglected child, these are the definitions of abused or neglected child. Child who's been abused or neglected by parent, guardian, or custodian. So let's go back to that 12-year-old who is pregnant. So you ask more questions. Who's the father? The father is my boyfriend. Do you have to report that?
How old is the boyfriend?
Does it matter?
Because I'd say statutory rape, though, if they're like 13, 14.
But do you have a duty to report that?
No.
Right? So these are things that, again, you don't have a duty to report that. It's something you may want to talk to her about. And then maybe there's other reasons. I mean, there's other reasons that someone so young is sexually active that you want to get into and ask about. But the duty to report only applies to abuse or neglect by a parent, guardian, or custodian. Your school may have different policies, though. You may have a policy that you report these things to at least someone within the school to make somebody else aware of it. But then we go back to, is that breaching confidentiality? Because the duty doesn't apply. She's able to consent. It should be confidential. But again, it gets really tricky when we're talking about how do we best protect minors. Most people are working with kids because they want to improve their lives, help them, and that includes protecting them, right? And that's why we have these mandatory reporting statutes, kind of like saying, hey, adults, all of you have a duty to report this, but it's relating to a parent, guardian, or custodian. So when you get into areas like the healthcare provider who kept the rape confidential did the right thing. She did what the patient was asking her for, and that patient, I'm sure, trusted her because of it. But it's scary to then have the police come and say, "You should have reported that." There's actually, oh, I thought that was on this slide, but there's actually no duty to report a crime. None. There's no crime if you're not committing a crime. If you stand there and watch a crime get committed, you don't report it. There's no duty to report that. We don't have what's sometimes called a Good Samaritan law, or the duty to help or report generally. So the initial question, did you have a question?
I was just going to say
10 minutes, okay. So the initial question when considering whether or not to report, does the sexual activity of the child and surrounding circumstances create a reasonable suspicion of abuse or neglect on the part of a parent, guardian, or custodian? The person with the knowledge must be the reporter. And reporting should not be delayed by a policy that requires consultation with a manager. Individual schools should have their own policies about reporting. But ultimately, it comes down to you. If you fail to report something that you should have reported, you're the one on the hook. You're the one who could potentially be prosecuted for a misdemeanor. So it's really, a lot of it is just your own discretion, that if you have that suspicion that a child is abused or neglected by a parent, guardian, or custodian, then it's really just a question for yourself that, do I feel that I need to report this? Does this meet this criteria? Okay, this is the one that I thought was there. There's no legal duty under New Mexico law to report a crime other than abuse or neglect of a child by a parent, guardian, or custodian. So where does that leave you when a child needs help but does not want to report? It's just some practical suggestions. Help them develop a safety plan or encourage them to talk to someone who can help them create one. Like, what are you going to do when this happens? A child, let's say a student comes to you, they're 15, they're in an abusive relationship with a boyfriend. You might want to talk to them about a safety plan. How do you get away from this person? Can you set them up with someone who maybe has those specific skills to talk about domestic violence or whatever issue is happening? Talk to them about holding others accountable when they do harm. A lot of times people in those situations want to make excuses. Well, it's because I was late, or I made him impatient, or whatever. Going back to, no, that's not, their behavior is not okay, and you need to hold them accountable. And counsel them about the importance of getting help from supportive adults, sort of helping the child realize there's other people also who can help you. Maybe someone approaches you, but they're not comfortable telling you everything. They want you to point them in another direction. So these are all things we can do to help kids. Now this one is just the final exam. Maybe we'll make it through all of this. It kind of goes through different situations, but this is about Thomas. He's a 15-year-old male. He attends Highland High School. He's been feeling depressed and anxious. His mood has been affecting his academic, professional, and social realms. He thinks medication may help him. His friends suggest he go to the school-based health clinic. So this is school-based. We're going to assume that means it's not just located at the school, it's funded by the school. FERPA applies. He gets a referral to a psychiatrist outside the school. His friend tells Thomas that legally it must be confidential, and since it isn't his family practitioner, his parents will never know. Is John correct? Which of these do you think is the best answer?
D.
Yes, D is correct. That once he's out of the school system, he can consent to the medication and the treatment. The provider will have to inform his parents that he's taking it, which should mean that the provider's also informing him that he's going to inform his parents. And if his parents want the records from the school-based healthcare center, they can get that. So they will see the referral to the psychologist if that's in those notes. Now he's 17 and he's a junior. He plays football. He's doing well. One of the reasons he's doing better is he moved out of his parents' house. Now he's living with his girlfriend's family. But one night he gets tackled and he can't get back up. It's because Albuquerque High is awesome. Sorry, my kids went there. He's taken to the hospital in an ambulance, and the doctor says he needs to be admitted for observation. Can he get treatment without his parents' consent? And where's he living?
At his girlfriend.
Oh, yeah.
Right, and he's 17.
Yes.
Yeah.
So under several different statutes, yes, he can get that treatment. You guys already gave the best answer though. So issue spotting, questions you'll want to ask. Is this mental health care? Is it medical? Is it reproductive? What's the age of the child? And if you're looking at issues of consent, either so that you can counsel the child or because you suspect abuse, you want to know generally those rules. Where is the child living? And is the child a parent? So these are all questions to ask when dealing with a minor. Here's some of these statutes, which I'm assuming that you guys are going to get a copy of my PowerPoint, which is why I didn't go through the statutes too explicitly. I don't know how interested you are in reading them, but here they are if you want to take a look. Does anybody have any questions or comments? All right, so again, Pegasus Legal Services for Children, one of the services we provide is just helping children, advocate for them to get the health care that they are entitled to, and also helping to educate healthcare providers about when children can consent to treatment, how that affects confidentiality. And so if you have any questions, you can feel free to contact us. Sometimes we will give you general information, but we're generally going to tell you, here's the direction you need to look in, here's the statutes. But if you're a healthcare provider, you probably have lawyers that, there are staff attorneys that work with your agency that should have the ultimate say on how your agency is going to interpret that and create policies around that. For children, we do provide direct one-on-one representation that is either just counsel and advice or sometimes the brief service of helping them get that medical care that they need. So that's where you can send children if you need that. We also do services like emancipation, special education law, guardianship, and really just generally everything that relates to youth, especially homeless youth.
Well, I have a couple of things that I thought about as you gave your talk, and thank you very much. It was very informative. One is, it seems like it's just crucial that you come up with some kind of policy, not just your personal policy. Like, I used to provide direct care to families and children as a social worker, as a behavioral health. So you work out your own policies about, but then you think, what is the policy for the clinic? And that we all get on board. And Jen Robinson, when she gave us our first talk at the beginning, talking about adolescent-friendly clinics and healthcare, she really spoke to developing those policies and getting them in place so that every time you're not trying to have to figure out which roads you'll go down with a particular child.
Right.
So you can just build that in place.
But even when you do that, I think you can see here, and you can probably are thinking of some of your own experiences with children, there's gray areas. So that's why it's so important to, as you find yourself going down that path, to let the child know, okay, we're getting into an area here that I may not be able to keep confidential.
Right.
I think that's, I mean, it's a fine line because you don't want them to say, well, then I'm not going to talk to you. Right. You want them to feel safe talking to you, but also part of that is if you're then required to disclose that later and you didn't advise them of that. I mean, I have represent kids who that happened to them once and now they won't see anybody, especially for mental health care treatment. If one's confidentiality is breached once, now they don't trust any provider. And that's really sad because then they're not going to turn to anyone for help maybe ever. And so no pressure, but don't do that.
I actually have a question about mental health. So it said like medically necessary for children.
Right.
How do you determine that though without actually talking to them about it? Does that make sense?
So that's not mental health though. That's medically necessary if they're 14 or older and they're living away from their parents. It's medically necessary. Right. So again, that's discretionary. So sometimes the one that I've been dealing with a lot this year is dental health care. Is that medically necessary? Some providers say, yes, it is. It's absolutely, even a cleaning is medically necessary. But I have also had to fight for a client to get a root canal, which the client was in horrible pain. It was, causing ear pain and all kinds of pain. And we had to say to the provider, come on, how can you say this is not medically necessary? Had to get her primary provider involved to say, this is medically necessary. So it's discretionary.
Okay.
And I think you do have to get some information about, I mean, that's
What's
just
going
sort of
on.
inevitable. Like, why are you here to see the doctor before going into the confidentiality and all that?
Question about the definition of custodian,
So,
just for like my knowledge. So if saying that if a patient doesn't want to disclose that something that happened to them, let's say it was like their uncle or their babysitter, something like that. How do I define a custodian to know if I legally need to report it or not?
I think there's actually a definition in the statute which that talks about custodian. But like, for instance, in abuse and neglect, let's say there's a step parent living in the home who cares for the child, or but doesn't have any legal rights to the child, but they are the person taking care of the child. They can get charged with abuse, and they can not charge. Well, they can get charged too criminally, but they can be part of the abuse and neglect petition. And we see that even in cases where it's like a girlfriend who doesn't live there but sometimes cares for the child. So I would say, look at the statute. I can send you the statute for the exact definition, but the way that CYFD has been interpreting it includes those people who are providing care for the child. So that's why it also says parent, guardian, or custodian, which just means there doesn't have to be that legal relationship. They don't have to have legal rights to the child to be able to abuse or neglect the child.
The other interesting thing is that explanation of benefits. And for a little while, I sat on a committee here in New Mexico to work on that. Medicaid has figured that out.
Yes. Yes.
If Medicaid can do it, why can't our big payers? And what my question was, and I guess I'm just ranting a little bit on my soapbox about this, but thinking, how are you getting away with that? Sending those explanation of benefits when the child has the right for confidentiality.
Right.
But moving press or United or Molina on this right now in New Mexico is crazy. And I'm thinking if Medicaid can figure it out, people want to just downplay the services of Medicaid or call them dysfunctional or whatever. But that was a thoughtful response because we have so many children accessing healthcare through Medicaid, right? And they can figure out how to suppress those ELBs.
But it makes you wonder if they want to. Like maybe they're thinking the parent won't pay if they don't have the information. I don't know. I mean, because Medicaid, you're right. Medicaid has showed that it's possible, even on a really large scale.
Yes.
So you really have to wonder why they're not doing
it. And there's some judgy stuff going on about what kids, how they're living their lives and what things they're accessing healthcare for, and that we, as the grown-up adults writing policy for a Presbyterian health plan, don't think that's okay.
Right, because New Mexico's law is different, and where we come up against this, where we see the difference in other state laws. For instance, in the foster care system, when you are sending a child for placement out of state, that state has different laws, and the child's going to be subject to those laws. And sometimes that's like if there's a child in a state where they can be forced to take medications, we get into it over what law applies here. And so you have to remember these companies are also providing health care to more than just New Mexico. Right. Maybe they don't want to tailor policies for every state. I don't know how to, because, New Mexico, we have like the Salud is our provider.
Yes.
So they're just for New Mexico, or at least Centennial. Okay. I can never keep up. They're always changing. But so I don't know. Maybe it is a difficulty, but I sometimes wonder if it's just that they aren't really that interested in it. Because the people who are paying are the ones who are entitled to the information. The parents are paying. So let's give them the information. I don't know.
Well, thank you. That was great and very informative.
Sure. Good.
I just want to ask one more time for people who out in virtual land, if there are any questions that you have for Ms. Romero before we end our session today. Okay. Well, thank you all for coming on. We really appreciate it. Please chime in that you were here. If you want any CEUs or CMEs, you can use the text box, chat box, and Kevin will catch you. And otherwise, go out and have a super great Wednesday. Next week, we'll be talking about the medical management of overweight and obesity in youth by Jane Beckley. She gives a fabulous talk. We hope to see you back, and have a great week.
And real quick, this is Kevin, a question about copies of the slides. the place where you registered for the session for today on our calendar, envision.nm.unm.edu. Go to the calendar and click on today's session or any future sessions, and you can download the slide set for that session. So you can always email me if you have any questions about that. It's kwerling, KWERLING @salud.unm.edu, and I can help you out with that. And again, thank you everyone, and we'll be signing off. I'll leave the room open in case you have questions for us through the chat box, but we are signing out.